Hello everyone, I welcome you back to our channel. This is Legal Mindset at the back. We thank you very much for your return by subscribing, by sharing. We urge you to continue such that we go on and do the things together. So, in today's topic, we are going to look at an interesting case in constitutional law. That is the case of Uganda versus Commissioner of Prisons, Exparte Matovu. This case is so paramount. It is so crucial in Uganda's constitutional law. Now, you cannot appreciate constitutional law minus understanding this case. The leading judge in this case was Sir Udoma, the Chief Justice. Now, one of the most constitutional law cases to respect in Uganda since it attained its independence is the case of Exparte Matovu, because it has drawn a precedent which many courts are following. Now, we are going to see its background, what brought up this case. So, shortly after Uganda's independence, there arose a constitutional crisis in 1966 when the Prime Minister, Milton Obote, suspended almost all parts of the 1962 independence constitution, and he introduced the 1966 Pigeon constitution. Milton Obote had a serious grudge with Kabaka Mutesa to the president. He exiled the Kabaka to Burundi, but the Kabaka sought asylum to England. Now, he also abolished the federal states, which we had acquired at Marlborough and Lancaster. He abolished all the traditional rulers. He wanted to make Uganda a republic. So, Michael Matovu was one of the Saza chiefs in Uganda in Masaka. He largely protested what Milton Obote had done. He was questioning himself on the validity of the new government, the validity of the Pigeon constitution. He put up a very strong protest. Now, he was arrested. He was taken to Masindi Port and re-arrested again, and was also taken to Luzira. While in Luzira, through his lawyers, he applied to the High Court for a writ of habeas corpus. Remember, the writ of habeas corpus is one of the non-derogable rights. It cannot be denied. Produce him dead or alive. That is Article 44, Clause D of the 1995 Constitution. Now, court found out that the case was lacking. It lacked very much. It did not show the motion, very much things. But because it concerned the human rights, personal liberty, court said, let substance prevail. The case of Michael Matovu was hard, even though it was lacking. Now, we are going to look at these issues in the case. Number one, we shall look at the validity of the constitution. We shall look at the validity of the government. We shall also see whether the detention of Michael Matovu was lawful under the 1966 Constitution. So, to start with the validity of the government, we shall see that court stated that when there is a new order, the judiciary follows it, regardless of how it has come, either by a coup d'etat or any other form. The new order suppresses the old order. For the judiciary, it just follows the old order. Court respected what they call the political questioning doctrine. It refrained from going into politics. So, if you go to the case of Dosso versus Attorney General for Pakistan, Justice Muhammad Munir held that certain acts of the executive are political in nature and the judiciary cannot review them. He used and relied on the Annis-Kelsen theory of revolutionary legality. The Annis-Kelsen theory of revolutionary legality states that a revolution is a law-crafting fact. Once it is successful, it becomes a basic norm, and all actions under it are valid. If you Let me give you an example of a case. The case of Major General David Tinefuza versus Attorney General, where Justice Kanye Amba stated that the judiciary shall not interfere in the operations and affairs of government except where there is violation of human rights. You get? So, quote, refrained from questioning the validity of the government. It said that it shall follow the government, so as long as it replaced the old order. Take an example. Uh, if if my friend here, Council Joshua, takes over power of this government, according to the political question doctrine, the government, the judiciary, shall be bound to follow his new rule. That is the political question doctrine. Because he has come into power by killing people. If the judges start questioning his leadership. So let us now go to another issue, the validity of the Constitution, the 1966 Constitution. For the validity of the 1966 Constitution, we are going to see that court also refrained from saying that the 1966 Pigeon All Constitution was invalid, because it clearly stated that where there has been a new order, it automatically replaces the old order. Maybe if it violates human rights, but if it doesn't violate human rights, the judiciary is bound to follow it. Justice Udo Udoma, the leading judge, stated that the legitimacy of the Constitution is determined by effective control. Once a new order is firmly established and accepted, the courts must recognize it. So, if you go to the other issue of whether the detention of Michael Matovu was valid under the 1966 Constitution, yes, court said it was. And if you go to the effects of or significance of this case, because we studied this case, it is in history, but we have to see what are its significance. This case has created a precedent which many courts are following now. Its citation has been heard in many halls of justice up to today. And if you go to the case of Opoloti versus Attorney General, where Opoloti was dismissed by the President Obote from his position as the Attorney General, what held that though there were inconsistencies in the dismissal of Opoloti, the President had the power to appoint and dismiss. The one who appointed you as dismissed you. The judiciary shall not interfere in some political matters. The political questioning doctrine. If you go to the case of Major General David Tinefuza versus Attorney General, Criminal Appeal number 1 of 1997, Justice Kanye Amba clearly stated that unless there is violation of human rights, the judiciary shall not intervene in the matters of government. That is it for the case of Exparte Michael Matovu. Uganda versus Commission of Prisons. I urge you to subscribe, share, and like our videos such that we move together. This is Legal Mindset at the Bar.